Well, another controversial Supreme Court decision was the Hobby Lobby decision. And you initially had said, Charlie, that you didn't think it would affect anybody here in Massachusetts, and that was a good thing, that you didn't want it to. You kind of got flack from both sides on that score. But what did you think about how would you clarify your impression of the Hobby Lobby decision?
It's sort of a good example of what I guess I would describe as maybe overthinking it a little. I mean, in my mind, what I thought was, well, we have a state law that's in effect for fully insured businesses here in Massachusetts that have to comply with the state law, and the federal law would apply to those self-insured businesses that don't have to comply with the state law. But you might run into situations and circumstances in which you have a company that's big enough to qualify under the federal law, not the state law, but meets the criteria associated with the Hobby Lobby decision. And so my solution to that was to have the family health piece of the Department of Public Health make available for any woman who works for an employer who chooses, because they can under federal law, not to cover 4 of those 20 available contraceptive measures, to be able to access that service through the Department of Public Health. And I'll tell you something, Peter, it's been very interesting to me that so far Martha Coakley, Steve Grossman, and Don Berwick have talked a lot about this decision, but I'm the only candidate in the race who's actually proposed a solution to it to make sure that women have access to those services if they happen to work for an employer who chooses not to cover them.
Yeah, and just to be clear for people who don't know the ins and outs of the Hobby Lobby decision, this was about employers citing a religious objection to supplying contraceptives through their health plan. And Mark, what was your perspective on that?
Well, Charlie mentioned there's 20 different contraceptions that came up in the case, and Hobby Lobby was against 4 of them. And that's what the decision was talking about. And the reason they were against those 4 is because technically they're not contraceptions. They allow conception, but then later on they end that life that was conceived. So here we have 16 contraceptions allowed. I would think that would be enough out of the 20, but this is a big government thing. Charlie's going to put hundreds of thousands of dollars of taxpayer money to go to pay for 4 drugs that violate people's conscience and are abortifacients. They're not contraceptions, they're abortifacients. They cause abortion. I think this has gone too far. I mean, why is government stepping in and proposing hundreds of thousands of dollars for these types of drugs when the Supreme Court has said no?
I mean, my view on that's pretty simple. We want to make sure women have access to those services if they want them. And I think in some respects, this makes it possible for employers to act in what they consider to be their religious interests, which, again, based on that decision, is perfectly appropriate, but at the same time makes it possible for women to access those services if they wish to. And I think that's about where we should be on this.
It's not just employers. There are taxpayers out there who feel the same way as Hobby Lobby did, and you're going to take their money and provide these services that violate their conscience. Be happy with the 16 that were approved out of the 20.